panel, we have about 5 minutes left, and I'd like to give everybody a minute to reply to a question. We're going to go in the order of presentation. So, Eugene, Perez, are any of the general plastic or Fintiv factors more important than the other factors?
I think when it comes down to Fintiv, at least, it's really, I think timing is a big issue. When you talk about parallel proceeding and there's a rocket docket scheduling order, it's going to be tough on the petitioner. Is it an advanced stage? Are you waiting close to the 1-year time bar to file your IPR petition? Timing is a factor, but I think if you looked at that factor 4 in the Sotero Wireless case, where you have a stipulation where your prior art issues in the IPR will not be brought to district court, I think that can be an important factor. General plastics, again, that's also a timing issue, I think. If you have the benefit of the patent owner putting response and or the institution decision, it looks like you're having a roadmap to perfect that second or third petition. So if you file it sooner, it's better. If it's a different set of claims, if it's newly discovered prior art, there's all factors. But yeah, I think when you file that second petition is also important. And I don't know if my colleagues have any other say, or Sally, if you want to move on to the next question.
If somebody wants to weigh in, fine, but we could move on to another question to Erin.
I just wanted to say quickly on Eugene's question, the factor 6, the catch-all factor, it's my experience that if the board thinks that the petitioner has presented a particularly strong unpatentability argument, that weighs heavily with the board as well.
Okay, then let's see if we can get this response from Erin. Erin, do we think the elimination of the presumption favoring petitioner will result in an uptick in the number of patent owners who file evidence with their preliminary responses? And if so, do you think that will impact the institution rate?
I would think that yes. For patent owners who were hesitant in the past, I personally think there will be an uptick in the number of those who elect to file some evidence with their preliminary response. And I think while it may not be great, I do think overall it will impact the institution rate. And I would think it would impact it in terms of lowering the institution rate just a little bit.
Thank you for that. Brian Murphy, I have a question for you before we close out. Does the Unilock 2017 versus Facebook decision mean that if the final written decision in the Apple IPR had been decided earlier, before institution of the Facebook and LG IPRs, then the circuit court would not have had jurisdiction to review the PTAB's estoppel decision? And if so, does that make sense to you?
Well, I think if the timing had been different, it would mean that the Federal Circuit would not have had authority to review the decision, because particularly if you look at Facebook v. Windy City and the Unilock decision, the Federal Circuit does consistently seem to be applying this rationale based on separation in time from an institution decision and a decision related to that institution decision. If there's any separation of time, even under the Joinder statute, the Federal Circuit seems to view that as a green light to review whatever they need to review.